वी आर नॉट पॉलिटिकल पर्संस। ये बागेश्वर धाम क्या है? ये आपने इसको पार्टी बनाया है? क्या है इसका स्टेटस? क्या है? कुछ तो रिसर्च करके आते हैं। आप पीआईएल करने आए हैं?
धीरेन्द्र शास्त्री बागेश्वर धाम सरकार द्वारा श्रीमद् भागवत कथा का आयोजन किया जाना प्रस्तावित है।
आप बोले तो इस ऑर्डर को क्वेश्चन कर देते हैं। किसी भी ग्राम सभा में कोई भी आयोजन करने के लिए अनुमति लेना आवश्यक है।
फॉर प्रोमोटिंग द हिंदुइज्म एट द ट्राइबल एरियाज,
जो मेरा बिलीफ सिस्टम है आपके भाषण से कैसे परिवर्तित हो जाए? स्पॉन्सर्ड पीआईएल मत लगाइए। मिस्टर काउंसिल, व्हाट्स योर गुड नेम?
उनकी धार्मिक भावनाओं को सर दिक्कत होगी, क्योंकि इसमें हिंदुत्व के बारे में सबसे ज्यादा वहां पे बोला जाता है। पेन ड्राइव में वो सारी बातें हैं।
ये पार्टी का प्रोग्राम है, बताइए ना। आपके सुर और आर्गुमेंट दोनों बदल रहे हैं।
धीरेन्द्र शास्त्री फॉर प्रोमोटिंग द हिंदुइज्म।
ये बीजेपी का फंक्शन है। आप जो बहस कर रहे हैं वकील साहब, हवा में बहस मत करिए। शास्त्री कथावाचक इज अलाउड टू परफॉर्म हिज कथा वाचन in district of Balaghat on 23 and 24/5/2023. Full stop. Next part. It is submitted that may have the effect of offending the religious sentiments of the tribal population, which is the majority population of district Balaghat, in as much as it is a predominantly a tribal district. Full stop. It is further submitted that ruling party is trying to misuse the goodwill of respondent number 7 Bageshwar Dham, bracket में लिख लीजिएगा, wrongly mentioned as respondent number 3.
My lord, it's a declared tribal area, my lord. That is clarified.
हाँ ठीक है, उसको कौन dispute कर रहा है? Who is a Hindu saint and that will disturb peace and harmony in a declared tribal area. Full stop. Petitioner's contention is that there are newspaper reports of this effect, that private respondent number 6 is trying to influence the local population through propagation of Hinduism. Full stop. It is also submitted that collector Balaghat on the one hand is facilitating the arrangement of programs and on the other hand has issued orders on 10/5/23 as contained in annexure P5 under section 144 CRPC 1973. Next para. Thus it is submitted that interests of the tribal population is at stake and therefore the impugned action of the authorities be set aside and organization of such katha vachan be stopped. Next paragraph. Reliance is placed on the judgment of Supreme Court in Dharamdat and others versus Union of India and others, AIR 2004 SC 1295. Full stop. Reading from para 35 of the said judgment, it is pointed out that table extracted after para 35 reveals that what are the nature of right and what are the permissible restrictions under clause 2 to 6 of article 19. Full stop. Reading from clause 1 bracket में है, another bracket small d and another bracket small e, it is pointed out that though gives right to move freely and obligor to reside and settle throughout the territory of India, but permissible restrictions are that the general public and the protection of the interests of scheduled tribe. Full stop. Thereafter, referring to
Para 68, my lord.
yes, I am coming to that. नहीं, उसके पहले भी para 64 it is pointed out that a two judge bench of Honorable Supreme Court in Indian Aluminium Company and others versus State of Kerala and others within bracket 1996 bracket close 7 SCC 637 had made an exhaustive review of the available judicial opinion and summed up the essence thereof in 9 points, 3 of which are relevant for our purpose, which we set out as under in colon dash within bracket 1. In order that rule of law permeates to fulfill constitutional objectives of establishing an egalitarian social order, the respective sovereign functionaries need free play in their joints so that the march of social progress and order remains unimpeded. The smooth balance built with delicacy must always be maintained. Next page. Similarly, placing reliance on the judgment in Srimati Indira Nehru Gandhi versus Shri Rajnarayan and another AIR 1975 SC 2299, it is pointed out that Chandrachud J. as his lordship then was, cited with approval the opinion of Harold Lasky that the within inverted commas separation of powers does not mean the equal balance of powers inverted commas close, and observed that within double inverted commas what cannot be sustained is the exercise by the legislature of what is purely and indubitably a judicial function, full stop. In our cooperative federalism, there is no rigid distribution of powers. What is provided is a system of salutary checks and balances, full stop, inverted commas, close. Next, reading from para 68, it is pointed out that Honorable Supreme Court observed that in the judgment dated September 10, 1990, C.W.P.No.9120 of 1999, the High Court within bracket bench presided over by the learned single judge within bracket close, unfortunately, unmindful of and expanse of the rights conferred by subclauses within bracket A and another bracket C of clause within bracket 1 bracket close of article 19 of the Constitution, did not correctly comprehend the scope of article 19 within bracket 1 of the Constitution and overlooked the fine distinction in breach of rights complained of by a citizen or citizens collectively but as citizens, and the right to certain activities claimed by an association, full stop. The High Court just confined itself to finding whether the impugned ordinance could be saved by clause within bracket 2 bracket close and within bracket 4 bracket close of article 19, and if not, then it was unconstitutional, also because it was too drastic and hence unreasonable. Next para. Placing reliance on this judgment, it is submitted that organization of a congregation of discourse by private respondent number 7 may have adverse impact on the social fabric of the tribal community and therefore indulgence be shown. Next para. Srimati Janvi Pandit, learned additional Advocate General, submits that there is no public interest in the petition. It is politically motivated. Full stop. Placing reliance on the judgment of Supreme Court in state of Uttaranchal versus Balwant Singh Chaufal, 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 2010 का 3 SCC 402 and reading para 181. It is pointed out that courts must encourage only genuine and bona fide PIL and effectively discourage and curb the PIL filed for extraneous considerations. Full stop. It is submitted that present PIL is loath with extraneous considerations and political motives. Next para. It is also pointed out that it is not mentioned by learned counsel in his petition that under which provision of law permission was required to be taken by the respondent number 7 from the concerned Gram Panchayat in terms of the provisions contained in PESA Act. Full stop. It is also submitted that as far as Annexure P2 is concerned, that is with a view to maintain law and order because district administration is expecting a huge gathering of persons looking to the past history of respondent number 7, and it is their duty to oversee that no issues in regard to law and order are created causing inconvenience to the common man. Next para. It is also submitted that another order passed by the district magistrate under section 144 CRPC is only to the effect and to educate the public at large that they should keep themselves insulated from exchange of objectionable messages etc. on public media as that has the potential of disturbing public peace, law and order. Full stop. Thus, placing reliance on the aforesaid judgment in case of state of Uttaranchal, it is submitted that there is no public interest and petition be dismissed. Next paragraph.
If I may also point for a moment, Your Lordship, I'm sorry to interrupt. If I may also point out, this order dated 2nd May 2023 has subsequently been modified. That is, they have not challenged, as per my instructions.
When was it modified?
It was modified, Your Lordship, as order, but on 5th of May. It is a.
Where, have you bought it on record?
It is not on record, but I have a copy.
Srimati Janvi Pandit further submits that order dated 2/5/23 was subsequently modified by the district collector and district magistrate on 5th May 2023 and said order has not been challenged by the petitioner. Next paragraph. As far as the last submission is concerned, it appears to be an order of reshuffling the posting oblique placement of officials. That does not require much indulgence in as much as 2/5/23 and 5/5/23 are administrative orders passed by the district magistrate who has a duty to maintain law and order within his district. Full stop. It only, the order dated 5th May 23 only makes arrangements in a different format, deploying a different set of people, and that being an administrative exercise that does not call for and cannot be interfered in the discretion in the exercise of judicial discretion of this court, as that those orders are specifically within the domain of administrative discretion vested in administrative discretion and administrative authority vested in the district collector and district magistrate Balaghat. Next paragraph. Petitioner's preliminary argument is that in terms of provisions contained in section 4 within bracket D of PESA Act 1996 and 4 within bracket F of the said act, इकट्ठा कर लेना, F, without taking concurrence of the Gram Sabha, no function could have been organized. Next paragraph. A plain reading of provisions contained in section 4D and 4F which reads as under, ये मैं आपको ये ले लीजिएगा, इसको कोट कर लीजिएगा हिंदी में, 4 घा और 4 चार, ठीक, makes it abundantly clear that section 4D of the Act of 1996 provides that every Gram Sabha shall be competent to preserve and
If I may,
save the traditions, modes, cultural identity, resources of the community, and for disposal of disputes in a conservative society by conserving and preserving their traditional methods. Full stop. Similarly, section 4 within bracket F provides that it is expected of every panchayat at village level that it shall oversee the implementation of the prescribed schemes, programs and projects meant for the said panchayat by using by making optimal utilization of the amounts so sanctioned and obtain their certification. Full stop. Thus, a combined reading or a separate reading of provisions contained in section 4 within bracket small d and 4 within bracket small f does not bring home that there is any provision for taking permission for the Gram Panchayat to organize any religious or public function. Full stop. Thus, first limb of argument put forth by learned counsel for the petitioner that without permission of the Gram Sabha, no program could have been organized is not made out. Full stop. We have given a careful reading to Schedule 5 of the Constitution of India, which according to the petitioner will be applicable to the facts and circumstances of the present case in as much as Balaghat is a notified tribal district. Full stop. There is no provision under Schedule 5, fifth schedule to the Constitution which provides for provisions as to the administration and control of scheduled areas and scheduled tribes. Full stop. It nowhere provides that before undertaking any public function, concurrence of the Gram Sabha or Gram Panchayat is necessary.
My lord, may I submit?
Full stop.
नहीं, एक पार्ट है सर, वो इसीलिए आपको बताना जरूरी है। ये उसी का जो 4 के आगे दिया हुआ है। अनुसूचित क्षेत्रों में पंचायतों को ऐसी शक्तियां और प्राधिकार प्रदान करते समय जो उन्होंने ये उसी के सर पेज 2 पैसा एक्ट का पेज 2 दा
कहाँ है?
चौथे नंबर पे सर, 5वें नंबर पे सर। अनुसूचित क्षेत्रों में पंचायतों को ऐसी शक्तियां और प्राधिकार प्रदान करते समय जो उन्हें स्वायत्त शासन की संस्थाओं के रूप में कार्य करने में समर्थ बनाने के लिए आवश्यक हो, राज्य विधानमंडल यह सुनिश्चित करेगा कि पंचायतों और ग्राम सभा को उपयुक्त स्तर पर
बताना चाहिए था वकील साहब, लिखवा देते हैं। चलिए, और कुछ बताना है तो इस बारे में बता दीजिए।
और उसी का सर 6 सभी सामाजिक सेक्टरों में संस्थानों और कृत्यकारियों पर नियंत्रण रखने की शक्ति प्रदान की जाए।
ठीक है, चलिए ऊपर जहाँ पर अपन ने 4D और F लिखा है ना, वहीं उसको और जोड़ लीजिएगा। बता देते हैं। F के बाद में E H I J
So,
K L
M, Your Lordship, I'm handing over a copy of the English version of it.
वर्जन दे दीजिए। मैंने जो ट्रांसलेट करके लिखा है ना वो भी इंग्लिश वर्जन से सही लिख लीजिएगा, मैंने रफ ट्रांसलेशन कर दिया।
No, no, it was absolutely correct, Your Lordship, all the entire translation.
ये 4M भी लिख लीजिएगा, वहीं जोड़िएगा साथ में, इनका नाम डाल के। some places also places reliance on clause M of section 4 of PESA Act, which reads as under. It is submitted that the spirit of the Act of 1996 is that while endowing panchayats in the scheduled areas with such powers and authority as may be necessary to enable them to function as institutions of self-government, a state legislature shall ensure that the panchayats at the appropriate level and the Gram Sabha are endowed specifically with dash tarake within bracket Roman 6 the power to exercise control over institutions and functionaries in all social sectors. ठीक है, तो इसका भी उत्तर लिख लीजिएगा। Even this argument appears to be half-baked. Full stop. The true meaning and import of clause M of section 4 is that panchayats in the scheduled area will be given sufficient autonomy to function as an institution of self-government, for which purpose autonomy will be given by the state legislature, which will ensure that panchayat at the appropriate level and the Gram Sabha are empowered with 7 functions which are mentioned below clause M of section 4, full stop. Since Shri Prahlad Chaudhary has placed reliance on clause 6 Roman है bracket में, it is evident that it bestows Gram Sabha to exercise control over institutions and functionaries in all social sectors which are within the domain of the Gram Panchayat and not those functions which are beyond the Gram Panchayat. Full stop. As far as understanding of law goes, Panchayat is not, Gram Panchayat is not bestowed with the authority to maintain law and order in the district or within the Gram Panchayat. Law and order still continues to be the exclusive domain of the district administration under the 3-tier system of public administration. Therefore, when it is taken, it is seen from when the whole scenario is viewed from this perspective, then submission made by Shri Prahlad Chaudhary that any function which is required to be organized within the boundaries of a Gram Sabha require concurrence of a Gram Sabha is not made out, because Shri Prahlad Chaudhary has not brought any material on record that to organize a public or religious function, concurrence of Gram Panchayat is necessary. Full stop. Gram Panchayat of the Gram Sabha is necessary. Therefore, even this argument is not germane to the present controversy. Next paragraph. As far as annexure P5 is concerned, it is an order passed by the district magistrate in exercise of his authority under section 144 of Code of Criminal Procedure. Full stop. Section 144 Criminal Procedure Code deals with power to issue order in urgent cases of nuisance or apprehended danger. Full stop. It is evident from the order dated 10/5/2023 that based on past experiences in regard to law and order situation and foreseeing the apprehended danger, said order dated 10/5/23 has been passed. It is preventive in nature, and that order being preventive in nature does not provide any lever in the hands of the petitioner to twist it in such a manner to make this court hold that provisions contained in Article 19 dealing with religious and personal freedom can be controlled through exercise of said lever. Full stop. Therefore, that submission that Annexure P5 is contrary to Annexure P2 is also not made out. There are two distinct functions of the district magistrate. One is to prevent any uneventful happening. Second is to facilitate law and order by deputing appropriate functionaries, district functionaries, so to prevent any law and order situation. And therefore, both these orders, Annexure P2 and P5, in fact, actually supplement each other rather than being contradictory as submitted by Shri Prahlad Chaudhary. Therefore, this ground too is not made out. Next paragraph. As far as issue of political leverage and other aspects are concerned, when they are examined in the light of the judgment of Supreme Court, light of the judgment of Supreme Court in Dharamdat and others supra, it is evident that Honorable Supreme Court in para 35 of the judgment of Dharamdat has demonstrated that the framers of the Constitution could have made a common draft of restrictions which were permissible to be imposed on the operation of the fundamental rights listed in clause within bracket 1, full stop. But that has not been done, full stop. The common thread that runs throughout sub-clauses 2 to 6 is that the operation of any existing law or the enactment by the state of any law which imposes reasonable restrictions to achieve certain objects, comma, is saved, colon, semicolon, sorry. However, comma, the quality and content of such law would be different by reference to each of the sub-clauses within bracket A to within bracket small g of clause within bracket 1 of Article 19. Full stop. Next pair. Article 19 deals with protection of certain rights regarding freedom of speech, etc. Full stop. Clause A deals with freedom of speech and expression. Semicolon. Clause B deals with right to assemble peaceably and without arms. Semicolon. Clause D deals with right to move freely throughout the territory of India. Semicolon. And clause G deals with right to practice any profession, comma, or to carry on any occupation, comma, trade or business, full stop. It is not pointed out that if for respondent number 7 preaching is a profession or occupation, then how that is in conflict with the interest of the petitioners, especially the tribal population of district Balaghat, full stop. Once that is not brought out on record, then freedom of speech and expression of the respondent number 7 or right of the public of the Gram Sabha or the district of Balaghat or neighboring districts to assemble peaceably and without arms cannot be curbed merely on the basis of certain apprehensions of there being a political motive in the hands of the private respondent number 6, full stop. Such motives cannot, next paragraph, such motives cannot form backdrop of the public interest litigation. There is no material on record that any of the sentiments of the tribal population are going to be disturbed by preachings of respondent number 7, full stop. In fact, we are constrained to observe that petitioner has not dealt with and has not mentioned that what are the religious beliefs and practices of the tribal population and how they are in conflict with the preachings of the respondent number 7, full stop. In absence of any material on record, comma, when Supreme Court has itself held in case of Indian Aluminium Company and others supra that the rule of law permeates to fulfill constitutional objectives of establishing an egalitarian social order, comma, the respective sovereign functionaries need free play in their joints so that the march of social progress and order remains unimpeded, comma, this court is of the opinion that if we show any indulgence in the matter, then that will be disturbing the social fabric and disturbing the laudable object of the Indian Constitution to achieve egalitarian social order. Therefore, we refuse to show any indulgence in the matter, especially when petitioner has failed to show any violation of the statutory provisions contained in the PESA Act or Schedule 5 of the Constitution, or as to the provisions contained in Article 19 of the Constitution. Thus, petition fails and is dismissed.